Good. Let me just start the clock. All right. Welcome everybody to my presentation, Rescuing Nozick from the Anarchist. And today we're going to be talking about the book that's pictured here, Anarchy, State, and Utopia, written by the philosopher Robert Nozick. And this book is going to be very helpful in tackling a problem that's central to political philosophy. Why have a state? So to start off, we should start off with some of the crimes that have been committed by states. They've passed unjust laws, they've waged wars of aggression, and in many cases, they've murdered both their own civilians and innocent people in other countries. So right here, you can see pictured some of the most notorious dictators of the 20th century, like Stalin, Hitler, Mao Zedong, Mussolini, and Kim Il-sung. But these crimes are not by any means limited to dictators. Even the United States government has committed each and every single one of these crimes. And so this raises the question, if states have committed horrendous crimes, why not have anarchy? So you can see here pictured Lysander Spooner, who is one of the, I guess, individualist anarchists. I'll say more about what precisely that means in a moment. And Nozick is trying to answer the challenge put forth by anarchists like Spooner. So before we can actually get into the meat of the argument, we need to consider the framework that's shared by both Nozick and the anarchist. And in doing so, we're going to consider some key ideas: the idea of a state of nature, natural law, and equal rights under law. So first, state of nature. Some of you might be familiar with Thomas Hobbes's concept of the state of nature. I think that's like super unhelpful for our purposes. So just like put that out of mind. Here's a definition. I am in a state of nature if and only if I have not consented to be ruled by any legitimate government. Notice that means that we might all be in a state of nature right now. Provided that none of us here has consented to be ruled by any legitimate government. Now, the second important concept is that of natural law. The idea here is that there's an objective moral law that applies to us all in the state of nature. And this natural law protects our lives, our liberty, and our property, our justly acquired possessions. In other words, it protects our natural rights from infringement. And crucially, the natural law provides us with equal rights. And Nozick and the anarchist both accept that the equality condition is so stringent that we have even an equal right to punish criminals. Now, that might sound like insane when you hear that for the first time. But you should keep in mind that the right is only a right to punish criminals responsibly. And it might be that under any given circumstances, very few people are in a position to be able to punish criminals responsibly. But provided that you meet that condition, that you are able to punish responsibly, everyone has an equal right to do so. So that's the starting framework. And now we need to consider how we would go about justifying a state. So the idea here is that you'd have to start by showing that a state, it's permissible to establish a state. And then you would try to show that it is desirable to establish a state. For our purposes, I'm going to be focusing more on the permissibility condition. And if we were to show all of this, that would give us a reason to work towards a just state instead of working towards anarchy. So Nozick believes that it would be both permissible as well as desirable to establish a state. This is Robert Nozick, if you've never seen his face before. So Nozick has basically two stages to his argument. He starts off by trying to show that a state could emerge from the state of nature. And then he tries to show that this process of a state emerging does not need to violate anyone's rights. We're going to go very quickly through the first stage. it's more like background for all of you. The second stage is what we're really going to be focused on. So stage one, how a state could emerge. The idea is that in the state of nature, people fear being harmed by each other. And as a result, they are willing to pay for protection. And entrepreneurs are going to arise and be willing to provide kind of private protection services. And so you have various firms that are competing in a market with each other. And the firms are each providing a variety of services. They're providing protection, they're apprehending and detecting criminals, they're providing trials to determine whether the accused has committed the crime, they're executing punishments, and they're providing restitution to the victims of crimes. But there's a kind of special feature of this market. When there are multiple firms, clients from different firms might end up in conflicts with each other. And I don't want to go into this too much now. We could revisit it during the Q&A. But the basic idea is that this process of people getting into conflicts with each other results in only one firm being able to survive in the market, while all the other ones fail. We call this firm the Dominant Protective Association, or the DPA. And notice that this DPA looks a lot like a state. It's doing a lot of the things that a state does. It's the primary rights enforcer within the territory. But now the anarchist has an objection. States in general do not allow unaffiliated rights enforcers, what I call independents, to operate. So for example, this is Batman. Batman is an independent. He's an unaffiliated rights enforcer, and that's why the Gotham City government does not regard his activities as legitimate. The problem is that the DPA, it looks like the DPA is not allowed to block independents from operating because that would violate the equal right of all to punish. So it's not allowed to become a state. To be a state, the DPA must possess a monopoly on force. Basically, what that means is it needs to be the sole authorizer of rights enforcement activities. So Nozick has a response at this point, and now we're getting into stage 2 of his argument. Nozick thinks that the DPA protects its clients' procedural rights. So pictured here, if you're not familiar, is Atticus Finch, the famous fictional lawyer from the movie and book To Kill a Mockingbird. And his job is to protect his clients' procedural rights. Their right, when subject to an accusation, to be judged under a fair and reliable procedure. Now, when independents want to judge the DPA's clients, the DPA is going to say, well, look, independents, your procedures are too dangerous. They're unfair. They're unreliable. We're not going to let you go forward. And according to Nozick, that's how the DPA can lawfully prohibit independence. There's a problem here. This looks a lot like a might makes right view. And the reason is that Nozick has just given us no reason whatsoever to think that the DPA's procedures are going to be any better than the independence procedures. And so why is the DPA entitled to stop the independents from operating? All he can say is, oh, look, the DPA is stronger. And so it's able to do so. That looks like a might makes right view. Now, I think that we can salvage Nozick's argument by through a new theory of procedural rights, which I am now going to propose. So this is the first formulation of my theory. There's going to be a later formulation once we have some more terms under our belts. I'm going to start off just by saying what the theory is. I'm then going to give an example of the theory to help illustrate it. And then I'm going to just quickly apply it to the DPA. All of this before trying to justify the theory. So if two parties reasonably disagree about a procedure, each party has a right to act on their reasonable assessment, even if doing so requires some amount of force. So take an example. Let's suppose there's a murderer, and there's two parties, each of whom wants to judge the murderer according to their own procedure. One endorses capital punishment, The second does not endorse capital punishment. Let's suppose they have a discussion and they're not able to resolve the matter. I'm claiming that the first party is allowed to try to kill the murderer, while the second party is allowed to use some modest amount of force to try to stop the first party from killing the murderer. They're both allowed to act on their reasonable assessment. Now, if we were to apply this theory to the DPA, you see that the DPA and the independent reasonably disagree over the independent's procedures. And per my theory, the DPA has a right to use force to prevent the independent from acting. But here's the first problem you might have with my theory. If one party has a right to act, doesn't it follow that the other party must stand aside? Isn't that just what a right means? I think this is based on a mistake, an imprecise use of the term right. We need to distinguish, in order to be more careful, two kinds of rights: liberties and claims. So here's the definition of a liberty. I have a liberty to X, let's say drink coffee, if and only if it is permissible for me to drink coffee. Notice, by the way, that this implies absolutely nothing about what people are obligated to do. You can imagine a system in which all acts are permitted. It'd be a terrible system, but bear with me. In this system, people would have a right, have a liberty to drink coffee because they would be permitted to drink coffee. To know whether someone has liberty, all you need to know is whether it's permissible for them to do the thing in question. Now, we need to, but what about people's duties? That's where the idea of a claim comes in. So I have a claim to, say, drink coffee, if and only if others have a duty not to prevent me from doing so. So you have a thief pictured here. Supposing that I'm drinking my coffee and a thief comes along and steals my coffee from me. The thief has violated my claim because they were under a duty not to prevent me from drinking coffee, and their theft prevented me from drinking the coffee. And so there's the distinction between liberties and claims. And we can apply this in order to, so here, this is an unprotected liberty. An unprotected liberty is a liberty without a claim. So, for example, a boxer has an unprotected liberty to punch an opponent. So, supposing I'm the boxer and I'm in the ring with my opponent, it is permissible for me to punch my opponent. Therefore, I have a liberty. But it's also permissible for my opponent to try to prevent me from punching them. And so I do not have a claim to punch the opponent. It's a liberty without a claim. It's an unprotected liberty. So now with this with these terms under our belt, we can provide the second formulation of my theory that avoids the objection considered earlier. If two parties reasonably disagree about a procedure, each party has an unprotected liberty to act on its reasonable assessment, even though doing so requires some amount of force. So my theory, you might wonder why we should even accept my theory. Why should the anarchist accept my theory? I think it has at least two virtues that I want to talk about. And we're gonna take these one at a time over the next few slides. The first is that it addresses the problem of legal indeterminacy. The second is that it balances the compromise and conscience. So first, legal indeterminacy. The idea of legal indeterminacy is that when you have a set of laws, they cannot be expected to resolve all cases in advance. As an example, consider the Eighth Amendment to the Constitution, which prohibits cruel and unusual punishment. I think that this probably leaves room for reasonable disagreement about precisely what's cruel and unusual. So you have an electric chair pictured here, and in many states in the past, it was legal to execute criminals using the electric chair. You might very well think that there's room for reasonable disagreement about whether this is cruel and unusual. some might say, well, this is cruel and unusual. It's really painful and it's inhumane. We should not subject anyone, even the worst criminal you can imagine, to such a punishment. Others might think, no, this is an appropriate response that expresses the condemnation of the community, for example. And the person who kills a bunch of people does not have anything to complain about. This is an appropriate response. And so there's room for disagreement here about what's cruel and unusual. You might think that the idea of fair and reliable procedures is subject to a similar indeterminacy problem. There's room for reasonable disagreement about what procedures are fair and reliable. If I were to flip a coin, decide whether someone is guilty or not, that's clearly unfair and unreliable. But for other procedures, there can be room for reasonable disagreement. For example, concerning the appropriate burden of proof in a criminal trial. I see it as a virtue of theory that it indeterminacy head on, like it addresses it. It says, look, there is room for reasonable disagreement, and under those circumstances, people have an unprotected liberty to act on their reasonable assessment. And so the upshot of that will be that whoever is able to act successfully will be able to put their procedure, will be able to execute their procedure. And so my theory tackles indeterminacy. And now going to the second virtue of it, this second virtue comes out in response to a certain objection you might have. Why shouldn't we just avoid conflict at all costs, like Gandhi did? Why ever allow disputes about procedures to be resolved through the use of violence? Now, I think that the objection is correct that it is morally important to avoid conflict. So compromise is often good. But what it leaves out is that I think that giving one's conscience a hearing is also morally important. And as we'll see, my theory, I think, balances these competing considerations of compromise and conscience. So the idea here is that, when you compromise, there are certain moral benefits that go along with it. There are like morally good features of compromising, namely that it helps to avoid conflict. But I think there are also moral costs associated with compromise in that, we feel the pull of conscience. We might feel that very urgently, but in order to compromise, we may very well have to kind of turn away from the conscience, tell our quiet conscience to quiet down, and so on. And there are going to be times where the moral costs of compromise exceed the moral benefits. So if we return to the murder example and the two parties who are disagreeing about whether to use capital punishment, why is it so horrible for the person who opposes capital punishment to use a very light amount of force to prevent the first person who endorses capital punishment from operating? After all, the moral stakes in this dispute are incredibly high, and presumably both parties to the dispute are going to feel the pull of conscience. And if we think it's morally important to take one's conscience seriously, then it looks like some amount of force is going to be appropriate. And of course, the appropriate amount of force is going to depend upon the broad features of the situation, and it's going to vary from case to case. So I think if you buy this idea of moral costs and moral benefits and the importance of balancing compromise and conscience, you have that motivates my theory, right? The idea is that when the moral costs of compromise exceed the moral benefits of compromise, then it's appropriate for each party to act. The parties gain an unprotected liberty to act on their reasonable assessment. So if you buy everything I've said up to now, we've seen that we can apply my theory to the DPA. I want to make that argument in greater detail. And so that's what we're going to do right now. So if we recall the DPA, it is the primary rights enforcer within the territory. And as a result, it establishes rules of procedure within the territory that essentially operate as a legal system. Now, assuming that the DPA's procedures are reasonably fair and reliable, the fact that it has created a legal system is going to have certain advantages in terms of the public good. And the main advantage, I think, is going to be procedural predictability. The idea here is that, supposing I'm accused of a crime, it would be disturbing if I had absolutely no sense of what procedure is going to be used against me. Suppose I had no sense of whether, am I going to have a trial? Am I going to have a lawyer? Is there going to be a right to remain silent? Will I be able to cross-examine witnesses? Is there going to be a judge, jury? What? Imagine if the answer was just like, we don't know. We're not going to tell you. Your guess is as good as mine. That would be disturbing, I think. And so the legal system helps avoid that by specifying rules of procedure in advance. This has like three primary benefits, I think. It reduces the fear of being abused by rights enforcement personnel. It helps people to be prepared for accusations. And it allows judges, lawyers, and police to develop experience with a single set of procedural rules. But what about independence? If you're unfamiliar, this is the man with no name from the movie The Good, the Bad, and the Ugly, and he's a kind of prototypical vigilante. People like him tend to undermine procedural predictability. Vigilantes are not known for procedural predictability. And so it's reasonable for the DPA to stop the independents from acting in order to secure the benefits of procedural predictability. And so, per my theory, the DPA has an unprotected liberty to stop the independents from acting. And so it looks like it's gained a monopoly on the use of force, which we said was the condition necessary for being a state. But it's a special kind of monopoly. It's what you could call a legitimate de facto monopoly. De facto just means in fact. So it's a monopoly in fact. So let's take the de facto component. This is the idea that it gains its monopoly by exercising its unprotected liberty, an unprotected liberty that everyone has. So it's not as if the DPA is claiming some exclusive right under law that it and only it possesses. It is simply claiming the right, the unprotected liberty, that everyone has equally. And so, but the result of exercising its unprotected liberty is that it gains a monopoly in fact. And in that sense, it's a de facto monopoly. And it's a morally legitimate de facto monopoly because the DPA does not violate anyone's rights by exercising its liberty. And so it looks like the DPA is a state that has arisen without violating anyone's rights. And so the conclusion is that it is permissible as well as desirable to establish a state. As I said before, I was focusing mostly on the permissibility part, but we touched upon desirability when we saw the benefits that come from procedural predictability. And so it looks like a state can be justified. But the anarchist should not be too disturbed by this, because I have absolutely not said that any existing state is currently justified. What I've said is that we would be justified in establishing a state that meets certain conditions, namely a state that doesn't violate anyone's rights. It may very well be that absolutely no state currently in existence meets that stringent condition. But I'm not trying to justify what's been done in the past. I'm trying to map out a vision for the future. What should we be working towards? Should we be working towards anarchy, or should we be working towards the just state? And I think that we ought to work towards the just state. Thank you very much. It's time for questions, and I believe we are starting with Nicole.
Cool. I was doing the clapping emoji to, yeah. Can you all hear me okay, by the way? Okay, awesome. Thank you, first of all, so much. That was a wonderful presentation, and I've really enjoyed reading your paper throughout this process. So I'm just, I have like the written responses I believe you received, and then just like some extra notes. So a couple questions. Would you prefer I just like go through all of them and then you sort of answer it generally, or would you prefer I just go point by point?
It's a good question. I think go through it all, and then I'll do my best to
Sure. And
respond.
I can refresh you on like the points if, anyway. Okay, yeah. So,
Although, before you go
oh,
on,
go
sorry.
ahead. Yeah.
Maybe we could start off. Let's do the stuff that you sent me first, and then I'll respond to that, and then maybe we can open up the. I know you said you had some other stuff too, so then maybe that could be part of the kind of general Q&A, if that makes sense.
Yeah, sure. I mean that, yeah. So the extra stuff I wrote down was just sort of clarifying, like you have answered a lot of this
Sure.
already in your
Good. Good.
presentation. And so these are just sort of constructive questions to kind of just emphasize certain parts of the argument and hear more what oh, sorry, I just got the message. To hear more about what you would say, to these questions about, yeah, the reasoning. So I'll just read this verbatim. So first, obviously, there's a very strong connection drawn in the paper between, in here too, between procedural predictability and fairness. You state that, quote, maintaining procedural predictability is important for the public good, and those who undermine procedural predictability shouldn't be considered public servants, end quote. Further, it is claimed that, quote, by creating a de facto legal system, the DPA generates something of value. Procedural predictability that no one is allowed to undermine for frivolous reasons. The DPA is almost always allowed to punish independents who violate its procedural rights. A state has emerged from the state of nature without violating anyone's rights, end quote. That's paraphrasing a little bit, but I think, generally expressing the thing I hope to respond to. I will return to these quotes again soon, but for now, the upshot is that I'm not convinced that this predictability necessarily, or at least likely guarantees fairness and the preservation of rights in the way the argument seems to assume. This isn't so much an edge case, I think, as it is a challenge to like the logic here. What comes to mind, as you'd mentioned, is an authoritarian regime, the de facto legal system of which is internally consistent in this kind of required way and predictable, but which still leads to the punishment of people who a member of the state deems undesirable, etc. In ways that violate basic common sense human rights. And obviously rights is such a contentious term as we've gone over, but I feel like that's a separate question a little bit. But yeah, so I was just curious how the system might respond to that. And there's one other thing I wanted to mention that I wrote down about that. Oh yeah, I think this is also distinct from the justification questions at the end and more relevant to this kind of, again, this reasoning about how a state, a justified minimal state could be explained through this kind of procedural predictability. Yeah.
Yeah, good. That's a great question. So I think it would be a mistake to think that I am claiming that procedural predictability is in any way sufficient for the justice of a state. That's absolutely not what I've said. I never ever said that, right? So the authoritarian, I think later on you talk about how authoritarian cases, all of the authoritarian cases are excluded by the logic of my argument, because my argument is about the conditions that are required for a state to be justified. One of those conditions is that a state is justified only if it does not systematically violate its citizens' rights. So any authoritarian regime systematically violates its citizens' rights. Those are just criminal regimes, right? So my argument does not justify criminal regimes. So predictability, I said it's important for the public good, but it's by no means sufficient. You also need a system that, first of all, the content of the procedure has to be reasonably fair and reliable. You can imagine a system that's predictable, but that's also super unfair. And also, the system cannot just go about punishing people for whatever it wants to punish people for. It's got to be punishing people for actual violations of the natural law. Is that helpful?
Yeah, certainly. Yeah, that is super helpful. I think I also should have clarified that I meant necessary here in contrast to sufficient. Yeah, because I hadn't taken the argument to seem to claim that that was sufficient. But yes, that is good and helpful. I can move to the second question if you'd like. Cool. So secondly, it is stated that procedural predictability helps reassure people that public servants will be executing the procedures as opposed to rogue individuals hoping to gratify themselves. That was a quote. This is also touched on a bit earlier in the paper when describing an undesirable punisher, quote, gratuitously inflicting harm rather than serving the public good. I don't know if I'm fully convinced by this description, um, as it seems plausible to imagine a situation in which a public servant or a leader, or perhaps both, acts in the interest of a public good that is inextricably bound up with some kind of self-gratifying form of hate, perhaps bigotry, racism, etc. And just, drawing on the authoritarian regime example, in this sense, the public good and gratuitous punishment, I think it's reasonable to say, would be connected. And while the public good is respected and kept in mind here, it seems that if we are to take a common sense approach to the moral evaluation of the situation, public agents are not necessarily as neutral and rights preserving as the argument might suppose, given they do in this case act for a form of rights violating gratification. But you'd also address this a little bit in your last response, but more of a comment.
Sure. Yeah. I guess I'll go very quickly. I guess I would disagree about what public good refers to. So it sounded like you were claiming something like, well, if the community enjoys self-gratifying hate or something like that, that then providing that to them would contribute to the public good. I would say that those are like, I guess you could call maybe disreputable desires or evil desires. And I would just deny that satisfying disreputable or evil desires constitutes a genuine contribution to the public good. So that I would have a more objective characterization of the public good as opposed to a more subjective characterization of the public good. Is that helpful?
Yeah, definitely. Thank you. And I could go to the third question. Yes. So 3, I concede that toward the end of the paper, just related to the stuff mentioned earlier, you remind us that, quote, the state could maintain itself without violating anyone's rights, provided that everyone consents to state authority, end quote. While this reminder is helpful, I believe oh, wait. Sorry, this was the general overall question that we already answered. Never mind, next question. So this is my last overall question. It's more of a clarifying question, then I think that will be time for me. So it's a much smaller point, but toward the end of the paper, you say that, quote, the state could maintain itself without violating anyone's rights, provided that everyone consents to state authority. But a bit later on, it stated that, quote, we would be justified in establishing such a state even in the absence of universal consent to the state's monopoly. And while I think I might get the gist of like the difference between these two sentences, I'm just curious to hear a little more about how those differ and whether and how state authority and state monopoly have different meanings here. Yeah, so just a clarification kind of thing.
Yeah, good. Very good question. So the idea of this is a bit tricky. The idea of state authority is, I take it to include a de jure monopoly on the use of force, in which the state would be claiming an exclusive right held only by itself to say punish criminals. And in order for that to be legitimate, consent would be necessary, since within this framework, everyone has an equal right to punish. And then we need to elaborate what precisely that means. Within a de facto monopoly, a legitimate de facto monopoly is different because there's a monopoly in fact, but the monopoly is justified by appeal to a right that is held by everyone, namely the unprotected liberty to act on one's reasonable assessment of the situation. So the distinction hangs on the difference between a de jure monopoly and a de facto monopoly. Is that helpful?
Yeah, totally. That is the kind of clarification that I was looking for. So yeah, thank you so much. Those are all my questions. I think that's about time. Should we just open it up?
Yeah, let's open it up. Oh, feel free to raise, I mean, maybe raise your, I can't necessarily see everyone, so maybe raise your hand using the Zoom feature.
Can I ask a question?
Is that okay, Daniel? Yeah, sure, Tate.
Okay. I was wondering if there were parts of because I remember you were focusing your stuff mainly on one of Nozick's books. I wonder if there were parts of his book or parts of his account that you didn't include due to like time constraints or size constraints that would be good addendums to add at this point, or just like smaller kind of noting different arguments that did exist in his book.
Yeah, that's a really good question. Yeah, so this is actually a bit tricky. Part one of so the argument that I presented from Nozick is from part one of the book. Part one is actually, it's incredibly difficult, and it includes it raises certain interpretive difficulties. It can sometimes seem like he's making one big argument in favor of the state. It can sometimes seem like he's making like 3 different arguments in favor of the state, and he's kind of sloppy about disentangling what clarifying precisely what he's doing at times. And so there's also there's that. So and there's also there's another component to his argument that I don't go into, where he tries to show not only that the DPA can claim a legitimate monopoly on the use of force, but also that it's required to compensate the independents for the prohibition. And that just raises so many issues. And it's also, I think, one of the weakest parts of the argument, which is why I decided not to go into it. Maybe I'll go to Daniel first, and then I'll go to Anna.
Thank you, Kanishk.
Thanks, Kanishk. That was really, really interesting. Excuse me. So I have a question about something you said at the end, where you acknowledge that, like, look, no current state. One may reasonably think that no current state is just, that their monopoly on power is legitimate. I'm wondering if you think what you think the options are for current states. Then, is there a way for current states to do things to make their use of power just, or is it like, no, current states, forget it. You need to somehow be able to go back in time, or not.
Yeah, that's really good question, and it's a very difficult question because I think it really depends. So I think there are some things the state could do. For example, it would have to recognize the status of independent rights enforcers, and it would have to actually have appeals procedures for giving such independents an opportunity to present their case for why they should be allowed to operate. So this is something I go more into in the paper. That's one thing, because right now states just do not, as far as I know, states don't do that. They just say, even if you're better at it, we're the ones who get to do it. So that I think is not just within the framework that I've talked about. There's also just so many other things that the state does that are not just. So like I said, it wages unjust wars. So stop waging unjust wars. That's a big thing. You could argue that even borders might very well be unjust, because what precisely gives the state the right to erect borders when other people are not allowed to do? That's another problem. So it might be that you need so many transformations that while we could still call it a state, the kind of system we would have would be very, very different. It could still be a rather extensive system. So I did not talk about distributive justice. And so the size of the resulting state may depend upon what account of distributive justice ends up being the correct one. So if you take a view, a more patterned theory of justice, you may end up thinking, well, anyone would be entitled to adjust the pattern of distribution in order to realize the appropriate pattern. And those who hold distributive shares that don't correspond to the pattern are in some sense violating the rights of others. And so it need not be a minimal state, but it will be a very different kind of institution. Is that helpful? I'm sorry, I muted myself. Let me go to Anna.
Thank you for your presentation, Kanishk. And I'm sorry, I do intend to be seen. It's just my computer camera didn't come back on, and I didn't want to miss a word of your presentation, so I just stayed. So I'm sorry, I have a question about what you just said you didn't want to talk about.
Yeah.
Because the monopoly on force and the prohibition of independence from actually enforcing their own rights violates their rights, right? And you mentioned that Nozick suggests that there's going to be compensation for that, and the argument, I agree, is not very good. Because he himself, for example, says, well, you know, you cannot compensate for everything, and especially if it's a pretty massive violation. Say, there is one dominant protective association, but there are also 30% of independents on the territory, right?
Sure. Yeah. Yeah. Mm-hmm.
So, like, remember, he says that, like, the enforcement, like, if you allow anybody to break anybody's arm and then compensate them fairly, that's just wrong, right? Because
that's right. That's right.
going to be this widespread fear and such. So, like, he somehow helps himself to the move he kind of prohibits to others. And I know you mentioned it's too complicated, but, like, do you have any kind of insight as to why the rest of his theory is still okay if there is this kind of glaring hole in the justification?
That's a good question. I'm not sure I fully understand. So is the question about, because in my framework, I did not bring in the idea of compensation, and because is the idea that are you asking if there's any way to salvage the idea of compensation? Is that the notion, or?
What you mentioned, so my idea is, how is it the dominant protective association is not violating the natural rights of independence?
Yeah, good. Right.
It seems to do that. And then I think you mentioned that, and you said the answer was compensation, but, like, forget about compensation, but, like, why are they not violating their natural rights?
Right. So yes, so that's kind of what the presentation is really all about, trying to, because I think that you're right. Nozick is not really able to do it because the compensation solution that he provides is just super inadequate. And none of the other arguments really seem to work as well. Like I said, it seems like there may very well be 3 different arguments going on, and I only focused on the one involving procedural rights. He has the separate one about risk and another one about compensation. I think that argument doesn't work. The procedural rights argument is you know, what I try to do is try to and I go into this more in the paper. What I try to do is I try to show that the right of all to punish, which the independent is claiming, that needs to be argued for. And in the paper, I try to show that in arguing for the right of all to punish, you end up with really good reasons to support the theory of procedural rights that I proposed. And if you accept the theory and you apply its logic to the situation between the DPA and the independent, it looks like there isn't a right that's being violated. Because if both sides just have an unprotected liberty to act on their reasonable assessment of the situation, and if it's reasonable for the DPA to regard the independent's activities as bad for the really bad for the public good, for predictability, then the DPA would have an unprotected liberty to act on its assessment, and just from the definition of an unprotected liberty, it follows that it's not violating anyone's rights. There's no impermissible act going on. Is that helpful?
Yeah, I guess I'll think about this some more, but again, like, it seems that you then might want to explain why the dominant protective association would stand for a group of people who defend themselves rather than something else in that, right? Because in the state of nature, you're allowed to, like, band with your friends and defend one of you against somebody who violates that individual's right? But yeah, but thanks. And yeah, that's fine.
Good. That's helpful. Thank you for the question. Let me go to Ko.
Hi, my question is about, like, the clause you put in at the end of your, like, thesis about certain amount of force. and I was wondering if um, the state can act as the independence can with unlimited liberty. Like, where does the, I guess, certain amount of force like constraint arise from?
Yeah, good. So intuitively, um, um, if there's a dispute about whether or not to use a certain procedure, um, it would not be appropriate, for example, to kill the other disputant. So it seems like there would have to be some upper limit on the amount of permissible force. And there's no easy answers to this, but the idea is that you have to think about this idea of moral costs and moral benefits, right? There's a moral cost that's associated with using any amount of force, but it might be that the moral benefits of responding to one's conscience justify the use of force. But again, the moral costs of using force are going to be proportional to the physical and psychological costs of conflict. And so if the costs of conflict are super high, perhaps because of the weapons you're using, then the moral costs of using force are going to be very high. And they're probably not going to be justified by the moral benefits of using force. So in order to try to think through these issues of the appropriate amount of force, it's helpful as a model to think in terms of moral costs and moral benefits. Is that helpful?
I think it's helpful, but I think I still don't really understand, like, um, in your, I guess, initial assumptions where you laid out like what the framework, the framework the anarchists and both Nozick and anarchists agreed to, it didn't really talk necessarily about sort of like practical rationality that extends beyond like self-interest. Like, it doesn't seem like, is morality just about protecting everyone's self-interest, or is there like more to that? Do you see what I'm saying? Like, if like, you talk about like the state of nature, how it arises like justifiedly out of state of nature, through like, I don't know, market incentives, and then you like invoke things like public good. Like, are those the same things, like just protecting everyone's self-interest, or is there like consideration that goes in? To me, like the talk of certain amount of force seems like you're like invoking things other than like moral considerations beyond like self-interest, let's say.
Um, Good. There's a lot there. I'm not, so I think you might be reading certain things into my framework. So I don't think I ever said like, oh, morality is just about self-interest or rights are just about protecting self-interest. I don't think any, this is all based on kind of on the Lockean framework, John Locke's framework. And I don't think Locke would have said that rights are just about protecting self-interest. Oftentimes rights are about protecting the ability of people to make decisions for themselves, decisions that are often very much other regarding. So the decision to help somebody else that you've chosen to help, or to establish a relationship with somebody, or to join a community where you're part of something larger than yourself, voluntarily, as opposed to being coerced into a community. So it's just a mistake to suppose, I think, that this is all about self-interest. And so there can be moral considerations outside of just self-interest. Is that helpful?
Yeah, let me think for a minute.
Let me go to Jason then.
Yeah, hey Kanishk, that was a great presentation. You and I have talked about a lot of this stuff at length. So I wanted to ask a question about something that we haven't talked about yet.
Sure.
So I can imagine someone worrying. Worrying that your framework so far might actually give some support to certain sorts of wars that might seem unjust.
Right.
One sort of thing that's, interesting about the framework is that this right of all to punish, and that allows for parties who seem like they're completely disconnected, like seem like they have nothing to do with what's going on,
Yeah.
to insert themselves into situations to punish. So suppose, our just DPA over here
Right.
sees another DPA working in a geographically distinct location, and said, look, their procedures are not reliable. How much better would it be for the public if they had our procedures? In fact, we should be the DPA over there as well. And so
Right.
we're going to go over and, regime change or something. So you can
Yeah.
imagine kind of an imperialistic DPA. And I'm wondering if you think that there are anything in the framework that safeguards against that.
Oh, yes, that's really, really good question. I'm so glad you asked it. Yeah, I think there's a number of things that can be said. So yeah, so with unjust wars, a lot depends, I think, on the reasons why the war might be unjust. So one thing that comes to mind is that wars are super reckless. And whenever you try to fight a war to, say, overthrow even the worst dictator you can imagine, even Hitler, for example, you end up killing lots of kids in the process. You end up causing so much destruction in the process just because the tools that are available to you are so crude. So during World War II, we had an area bombing strategy where we just like, firebombed a bunch of cities, and we killed so many kids in the process, right? So many people who were not fighting. There was no trial, right? There was no due process. We just killed a bunch of people, and so that presumably would be impermissible. And so there are certain, in philosophy, that, as far as I know, there are intramural disputes about the principles governing self-defense and defense of others. And there are open questions about whether it's permissible to harm an innocent bystander in the process of defending yourself or others. And so I don't know the answer to that question, but then my view would be that whatever answer we have will then be applied to whatever just war theory we want. And so the DPA will be constrained by the moral requirements of whatever the correct just war theory is. And it may very well be like the only just wars would be like naval wars where there aren't any civilians in sight and you're just attacking other enemy soldiers, and only if you're in the right. So the burden of proof is going to be very, very high on the DPA. And it's, if they're using the kinds of the war machines that we use, the requirement that you not indiscriminately kill innocent people is going to do a lot of work in preventing unjust wars. Is that helpful?
Yeah, very.
Yeah, Doug.
Yeah, this really just occurred to me. But I'm thinking about these. Let's see here. Hang on a second. I'm thinking about these recent laws that, if I'm following how the laws work, they'll sort of deputize ordinary citizens and pay them to file civil lawsuits. And they're basically right. Basically, the idea is you can sort of deputize citizens to act like enforcers. Right. So
Yeah.
you might not be able to make abortion illegal in the courts, in the criminal courts, but you might be able to pay people's legal costs to sue people who have abortions and take it to civil courts or something like that.
Right.
To put it in a very, very broad way, does your theory give you a perspective on these recent developments, either, as it were, in favor of that kind of move or against it? On the face of it, it can look like the theory favors that kind of thing because it's sort of recognizing the rights of ordinary citizens to act as enforcers or recognizing their unprotected liberty or something like that. On the other hand, I have my worries about these recent developments. So
right. That's
I
a
don't know if
good.
you can. Yeah.
I'm sorry. Did I interrupt, or did you have more?
No. So if you could just maybe speak, if you have any views about these kind of recent legal developments, it'd be interesting to, from the point of view of the theory you just developed, it'd be interesting to hear them.
Yeah, that's a really good question. And I had not thought about that. I do have something to say. I think that So I will share, I share your unhappiness at the recent legal developments. I think it's very dangerous and I don't like it. But if I try to pinpoint the precise reason why I don't like it, I think it's because I'm pro-choice. That's the reason. And I think that I would regard the activities of such citizens as rights violations, because it would violate some sort of right to bodily autonomy, for example. And so I think in order to decide these cases, you have to look at the substantive issue itself. I'm not so much concerned about the mechanism as I am about the substantive issue. So I'm imagining other cases where we would maybe not be so disturbed by citizens acting. So you can imagine various authoritarian. Locke developed this framework in part, as far as I know, in order to justify the right of revolution against authoritarian regimes. And so you can imagine cases like the Nazis in during the 1930s, where there was like systematically unjust laws. And there were also presumably laws that should have been on the books that were not on the books. Laws against persecuting ethnic minorities, for example. As far as I know, those were not on the books in the Germany of the 1930s. And you might think that under such circumstances, it's appropriate for citizens to act to enforce the natural law and say, like, no, you cannot treat people this way. You can't hurt people because they're Indian, right? You can't just attack people that way. And if you do, and the government refuses to punish those criminals, people who say attack Indians indiscriminately, then it's appropriate to act. So there are cases where it's going to be disturbing that people are acting, but I think what's disturbing about it is that they're acting immorally for the wrong. They're doing substantively bad acts, and that's how I would assess the abortion case. Is that helpful? Or
yeah, I think so. So I take it the short answer is the mechanism on your view might actually be fine or good in certain cases. But this is a case where the background theory of rights is doing the heavy lifting.
Yes, that's right.
Yeah.
Okay, well, please join me in thanking Kanishk for such a thought-provoking presentation. And we will begin our in-person presentations next week. So please join us this coming Tuesday for Tate Johnson's presentation.